Let's talk a little about WOTUS and the risks of farm operations with the new WOTUS rule coming down and perhaps other regulatory issues, but I think we're going to focus on WOTUS for the most part today. Okay. I am a farmer who was prosecuted with threats of criminal penalties for planting wheat in a wheat field under the 2008 WOTUS rule. So this goes way back before Obama, before Trump, before the new Biden rule. And one of the concerns with the expanded WOTUS rule that's coming is farmers just don't know what the rules are. We don't know what prior converted cropland standards are. There's no universal definition that I'm aware of. There's no universal definition of what crop rotation means, or how farmers are to work under the new WOTUS rule to, in my case, I planted wheat in a wheat field that had been planted 20 years prior, and wheat markets in 2011 were high. There was a global food crisis, similar to what we stumbled on with the Ukraine invasion here recently. So we recommissioned idled farmland that had been grazed in agricultural use but hadn't been planted to wheat for a couple decades simply because markets didn't warrant that it be planted to wheat. Have you worked with the administration, or have you worked within the USDA to actively promote what exactly are the rules that farmers need to follow to be compliant with the new WOTUS rule as published?
Congressman, I encouraged EPA to, first and foremost, as they're developing a response to a court directive to develop this rule, to make sure that they met with farmers. And I was pleased to see that there were literally dozens of meetings that EPA had with ag organizations, that in fact they put together a farmer and rural advisory committee that included 30 farmers and ag stakeholders that made recommendations that were incorporated in the rule, that they had 10 regional roundtables, 3 of which were led by Farm Bureau presidents, state presidents in North Carolina, Arizona, and California. So to me, that's the first responsibility I have, is to make sure that they're listening to farmers. And then secondly, as they develop whatever the rule is going to be, whenever it ultimately gets finalized, our job at USDA is to say, okay, how can we help? How can we help farmers with conservation resources or whatever it might be to be able to comply? This is the challenge is we're going to continue to go back and forth.
Well, let me ask you this. You use the EPA as your lead agency to define what a wetland is or isn't and to communicate standards. They're not often interfacing with farmers. The USDA is oftentimes the lead agency interfacing with farmers, and many farmers plant their crops without a consultation of the EPA, as was the case with me. Another issue I'd love you to answer is I was prosecuted by the Army Corps of Engineers when I wasn't under an Army Corps of Engineers permit. And when the EPA wouldn't pick up the case and prosecute me, they went to the Department of Justice Division of Environment and Water and got them to prosecute me because the EPA wouldn't prosecute under our set of facts. Are you going to agencies outside the EPA and looking for what their guidance is in terms of what cases will be prosecuted by them if the EPA demurs?
Well, I think the first order of business, Congressman, is to get a rule. And we don't have that really. We have multiple rules in multiple jurisdictions. There's a great deal of uncertainty. And my plea is that we get some degree of certainty in this process.
Well, I would venture then, the rule is written, and the Obama rule was very similar. They defined wetlands with a lot of latitude given to the actual field agent at the very bottom of the organizational chart, as far as I understand, the Army Corps of Engineers and EPA, to determine based on their experience and expertise what is or isn't a jurisdictional wetland. So you not only have multiple agencies prosecuting with and without subject matter jurisdiction, but you also have field agents determining what is or isn't a wetland on their, quote, experience and expertise kind of on the fly. So I don't know how the administration seeks to have a unifying rule when they leave it really up to the field agent.
Well, I think there's an effort to try to be as responsive as we possibly can and get this thing finally done. I mean, we've been talking about this for literally decades. And the reality is it's a result of a law that was passed in 1972, the Clean Water Act. I think everybody wants clean water. The courts have directed EPA to do this, and they have to do it. So the question is, when are we going to have the rules in place that we actually know what the rules are? We constantly have court stuff back.
I would offer, as long as we look for an expansive definition of what is or isn't a jurisdictional wetland under the Clean Water Act, you're going to have pushback, and it's going to continue to vacillate back and forth. If the Army Corps of Engineers or EPA wants to regulate farmland in a way that's pretty much specifically excluded by the Clean Water Act and the 404 permit amendment that was done later, then I suggest they come back to Congress and seek that jurisdiction.
I don't know if I'm supposed to respond, the time is up, but the reality is the Supreme Court has basically created this directive, and federal courts are directing the EPA to do this. It's not like the EPA is doing this on their own. They're being directed to do this. They've got court direction.
Well, they've a single judge that said something about a significant nexus. We can go into this.
It's a federal judge.
So when the Sackett decision comes down here in a few days, weeks, months, the administration will take that direction, reopen this rule, and provide compliant rulemaking for that decision?
I'm sure that the EPA will do whatever the court directs them to do, because that's what you have to do.
Thank you.